What is Roman contract law? Have you ever wondered how agreements were made in ancient Rome? Roman contract law was a key part of their legal system, shaping how people formed binding agreements. This law ensured fairness and certainty in transactions, whether they involved buying goods or lending money. At the heart of Roman contract law were three essential elements. First, there was the thing, or res. This could be anything with value, like a physical object such as a chariot or an intangible right like a debt. The term was broad, covering all economic assets. Next, a price was necessary. This meant that both parties had to agree on the value exchanged in the contract. Without an agreed-upon price, the contract would not hold. Finally, there was the need for agreement or consent. Both parties had to mutually agree on the subject matter and price. Once they reached this agreement, the contract was considered perfect and legally binding. This created duties for both parties and transferred risks accordingly. Roman contracts came in different forms. One of the most notable was Stipulatio. This was a unique contract formed through a formal question-and-answer dialogue in Latin. One party would ask, "Do you promise?" and the other would respond, "I promise." This method required strict formalities but evolved over time to allow for more relaxed conditions, including written forms. Another type was literal contracts. These were written agreements that recorded debts or obligations. They could change an existing obligation into a new one or transfer debts between parties. While oral contracts were preferred for a time, written contracts made a comeback later. Real contracts were another category. These involved the actual delivery of a thing to create obligations, such as loans or deposits. Roman contract law also distinguished between rights in property, known as in rem, and personal obligations, referred to as in personam. This distinction helped clarify what was being transferred or promised in each agreement. In practice, Roman contract law was vital for commerce, property transactions, loans, and various agreements. It provided a structured legal framework that protected the interests of all parties involved. The Romans placed great importance on trust, obligation, and legal certainty in their society. Their contract law reflected this, balancing formal procedures with practical flexibility. This system allowed for a thriving economy and a well-functioning society.